Record this matter is before the court for the purpose of reviewing custody and parenting time. This hearing is being conducted via Zoom. The president is Attorney James Perchandral, representing the plaintiff father, Ryan Benore. Mr. Benore is present, and in addition, Attorney Leslie Carr is present, representing the defendant mother, Chelsea Benore, and Ms. Benore is also present. Parties were last before the court on June 18th. The court entered an order that limited mom's parenting time to being supervised at home with maternal grandparents. And the issue of custody and parenting time was referred to the front of the court for formal investigation recommendation. Has everyone received a copy of Ms. Scott's report? Mr. Perchandral,
yes, Your Honor.
Yes.
Yes, Your Honor.
Court is of opinion this is more of a parenting time issue. The parties have met with Ms. Pratt this morning for the front of the court to provide the court with the following recommendation. Parties will continue to share joint legal as well as joint physical custody of the two minor children. The court's aware that the judgment of divorce provided for parenting time as agreed, so it appears appropriate that we have a specific parenting time schedule in place. The recommendation of Ms. Pratt is that mother shall have parenting time Mondays and Tuesdays overnight, father shall have Wednesday and Thursdays overnight. The parties will rotate the weekends, with mother beginning August 16th, 2024, which is Friday of this week. The exchanges will be from school or 5 p.m. if no school. All communication between the parties shall be via app close regarding the children. The parties shall provide doctor's notes to the school in regard to absences and communicate the information to the other party. If a child misses school, the child should see a physician the morning that they're off school. And finally, the parties shall mediate with Ms. Pratt on September 16th at 1:30 p.m. That is a recommendation. Mr. Perchandral, is this recommendation agreeable with your client this morning?
There are parts of it that are agreeable. We agree and believe it's appropriate to use app close with the provisions about doctor's notes and providing it are agreeable. Mediation is agreeable and I believe appropriate in this situation. The other portions I do not. I can wait to hear what Ms. Carr has to say about the recommendation before I proceed, or otherwise tell you my concerns.
Whatever your pleasure, Mr. Perchandral.
All right. I would simply say I believe the recommendation really totally ignored the facts that led to this petition. We had serious problems with mother's care of the children leading up to this, both for drugs and supervision for school. The children had the oldest child had 41 unexcused absences. She claims she has medical information about those, but my client had no problem getting those designated as excused when the children were sick in his care. So she simply just didn't follow through. There were about 11 tardies as well. So she just couldn't get the children to school. This oldest child had attended Monroe Public Schools until last year. My client lives in Monroe. It's going to be much easier for him to get the children to school in Monroe. He believes that he's going to be in a position to do a much better job. We're glad mom is involved in a treatment program. She still hasn't behaved in an appropriate way during this break. We were supposed to have supervised parenting. My client tried to grant additional time only to find out they weren't always being supervised as ordered. When he raised that issue around the week of the fair, what he got back was a photo containing mom, her mother, and the children, where she's giving my client the finger. She's acknowledged that and given an excuse for that, but that's not disputed that she sent that to him. I just think that shows her maturity level isn't in a position isn't where it needs to be to handle this. We think my client should be allowed to return the children to Monroe schools. that he should have primary parenting time. And if the court wants to lift the supervised provisions, that would be one thing. But we just, all the history that led up to this motion and mom's conduct since hasn't really been considered in this friend of the court record.
All right, thank you, Mr. Perchandral. You referenced the children returning to Monroe. They've never attended Monroe. They've always attended Jefferson. Is that not true?
That is not true. The only year Jefferson was attended was last year. The attendance was at Monroe, and for the oldest child, that meant kindergarten, first, second, and I believe third grade.
Okay, and the court's aware that the youngest child has an IEP. Was there an IEP? Did Mr. Benore participate in that process at all?
No, he did not.
Reading the pleadings, it was suggested that he did not participate at all in that process, which is important if he wants to be the primary parent for schooling purposes. And that was alleged by Ms. Carr, by Ms. Benore, that he did not participate in that plan. I was just asking if that was accurate.
Sure. I believe that's accurate, Your Honor. However, that plan is transferable to Monroe, as Ms. Pratt mentioned to the parties, if the children go to Monroe.
Is it too late to all of a sudden change school districts 2 weeks before the beginning of school?
I do not believe so.
Okay. Right. So you're primarily opposed to this parenting time recommendation, correct? You want the children to primarily live with dad and go to Monroe High School?
Go to Monroe Public Schools, yes.
Ms. Carr.
Thank you, Your Honor. We do agree with the recommendation. We agree that the children should remain in Jefferson schools. I would note that the reason the school change happened was because neither party was living in the Monroe Public School District. My client was living in Jefferson School. She was the primary caretaker at that time, and had both children were were at Jefferson Schools last year, and my client did participate in an IEP. The youngest child has autism. They have a specialized plan in place. My client's been very happy with how that was planned for the youngest child and believes that that is the best place for the children at this time. My client does not have a drug problem. It's been stated on and on by Mr. Benore that she has a drug problem, but she does not have a drug problem. There's never been any proof of that. My client has been on some pain management medications previously during the course of their marriage, was on these medications because she was in a terrible car accident many, many years ago. She was weaned off those medications, is on one new medication for her pain management from that car accident. She is not taking, he makes it sound like she's taking illegal drugs, and she's not taking illegal drugs. She provided a drug screen to Ms. Scott. She also provided all the attendance records to Ms. Scott, including the doctor's notes from when the children went to the doctors to Ms. Scott's. And I would note that when Mr. Benore was married to my client, the child had more absences in Monroe Public Schools. It is not a fault of my client. The children were sick on numerous occasions last year. In terms of the communication between the parties and the parenting time, my client did have her mother with her. They were supervised that entire time. If we have to have a hearing, my client will have her mother come and testify, and other people come and attest to that supervision. Somebody sent a picture to Mr. Benore or talked to Mr. Benore and said they saw my client at the fair with the kids, and didn't say anything about supervision. That a blow up by Mr. Benore ensued. That language was used that was not appropriate toward my client. And yes, my client sent a picture that she shouldn't have sent. She's regretful that she did that. But that goes to the communication between the parties, which is why we agree that at close is the best way to communicate. But my client went on a vacation, allowed my client to have, or Mr. Benore went on a vacation, allowed my client to have overnights with the children. They thoroughly enjoyed that time with their mother. She's not on any type of illicit substances. There's no reason to have the supervision to begin with. And we want to maintain that Jefferson School District. My client was very, very pleased with how the children did in Jefferson as opposed to Monroe Public Schools. And she even went and got a job. So she's working at Jefferson Schools while the kids are attending there. So we're requesting that the school district remain the same and that the court enter the recommendation by the friend of the court.
And Ms. Carr, does your client reside with maternal grandmother?
Yes, she does.
Okay. All right, anything further, Mr. Perchandral?
I would just, in response, mention, yes, my client was working. Neither last year lived in the Monroe Public School District. He does now again. Mom wasn't working, so she was in the best position to take the kids to school. Unfortunately, her record in doing that's exactly the problem, both there and when my client was working and they were going to Monroe. That's part of the reason he's saying, put them in my care. We're going to do a better job. The mother, yes, she is taking drugs. She's saying they're legal drugs, and that may be the case, but that doesn't explain away her problems that were referenced by the children in the initial petition of her bizarre behavior, her actions that caused her own mother and the kids to lock themselves in a room, etc. So there may be problems she's having with her pain management program. And nevertheless, they're real, and her failure to get the kids to school repeatedly is real. So it's a legitimate request. It's going to be easiest for my client to handle that at Monroe, and certainly mom has demonstrated she isn't up to the job.
Thank you. The court was of the opinion that the recommendation of Ms. Scott was reasonable. Of course, the recommendation of Mr. Pratt this morning actually provides Mr. Benore, plaintiff father, with more parenting time than Ms. Scott would have suggested. She suggested alternating weekends during the school year, or 3 weekends per month, long weekends, Friday after school to Monday to school. Ms. Pratt is providing more 50-50 parenting time between the parents. Okay, I'm informed we lost Mr. Benore. We'll give him a minute to zoom back in. For the record, Mr. Benore we lost him, but he's back in now. And once again, the court is of the opinion that Ms. Scott's recommendation was well reasoned. And the recommendation of Mr. Pratt this morning actually provides more parenting time to Mr. Benore, plaintiff father, than Ms. Scott would have recommended. The court, yes, is concerned about school attendance. It's a legitimate issue, and then we can monitor that closely. The court notes that the parties were just divorced earlier this year, and they agreed to joint legal joint physical. No reason to change the custodial environment. And it's simply a parenting time issue. The parties previously agreed parenting time as agreed. Obviously, a specific parenting time schedule appears to be more appropriate at this point in time. The court believes the recommendation of Mr. Pratt is appropriate at this time. Particularly, the court's going to mediate again on September 16th. If there's issues of the unusual and inappropriate behavior on the part of Ms. Benore, Mr. Perchandral can always again ask for drug testing. We can closely monitor that she's not abusing any prescribed medications and that she's getting the children to school on time. If there's absences, we can bring right back before this court. But at this point in time, the court believes that the children need consistency, continuity, especially at the young ages, 10 and 5. So the court needs to address the school issue raised by Mr. Benore, and the court will order that the children continue in Jefferson schools until further order. Mr. Pratt, can you add that to the recommendation, please? That children will continue in Jefferson schools until further order.
Yes, sir.
Thank you. Just address that issue. Court will be available on September 16th at 1:30. If in fact there's requests for an evidentiary hearing or there's other issues that we need to address, the court will be available on September 16th. If you want to simply let us know, you can appear before the court after you have concluded your mediation with Mr. Pratt at 1:30 the afternoon. Again, the remainder of the recommendation the court will adopt. If the child's going to miss school, the child needs to see a doctor that day. And mother's parenting time will no longer be supervised, but at least we know where she's residing. All right, anything further this morning, Mr. Perchandral or Mr. Carr?
No, Your Honor.
No,
Okay,
Your
all
Honor,
right,
thank you.
The court will adopt the recommendation. I will conclude this matter. We'll see everyone if necessary on September 16th after the 1:30 mediation.
Thank you, Your Honor.
Thank you, Your
Welcome.
Honor.
Thank you, Your Honor.
Thank you, Your Honor.